In this class, we will discuss about Supreme Court provisions in the Constitution. Supreme Courts, it is covers under Union Judiciary. This chapter in the Constitution under Part 5. Articles covered are 124 to 147 of the Constitution. 124 to 147 of the Constitution. First, if you take in Government of India Act 1935, there was Federal Court of India. Federal Court of India. So Supreme Court replaced this one. Supreme Court replaced this one. There is also British Privy Council. This is highest court of appeal during British time. During British time. So Supreme Court replaced this one also. So Supreme Court replaced these two. Then finally of 28th January 1950, Supreme Court inaugurated. In India, we have single integrated judiciary. Integrated judiciary. This is what unified judiciary we will call. This means if you take, there is Supreme Court and down there is High Court and down there are subordinate courts. Subordinate courts will come district courts and below. District courts and lower courts. Of course, if you take Supreme Court, it is functioning, you can say, at central level. And these high courts each state. And these subordinate courts, if you take district courts at districts level. At districts. This is at each state. Supreme Court sitting at Delhi. But what here important point is, these all will see both central law plus state law. This adjudicates, Supreme Court, High Court and Subordinate Court adjudicates both central law as well as state law. So that's why we call this is a unified judiciary. If you take United States of America, there is a federal judiciary. That is, you can say, Supreme Court. Okay, there is Supreme Court which will see only federal laws, means central laws. Federal laws only it will see. Whereas High Courts, it will see only state laws. So in America we say double court system. Double system of judiciary. Double system of judiciary. This is in USA. So in USA there is double system of judiciary. Federal court, that is Supreme Court, will see only federal laws related disputes. Whereas High Courts, they see only state laws. But if you take in India, we have single unified judiciary. These all Supreme Court, High Court and Subordinate Court and lower courts. These all organically linked. Okay. For example, if you take the judges from Subordinate Court will promote to the High Court and High Court judges promote to the Supreme Court. And here one both central as well as state laws are adjudicated by these all courts. If there is no Supreme Court has to see only central law, no, there is no such division. Supreme Court we can see both central laws as well as state laws. Similarly, High Court, similarly subordinate courts. But the difference is Supreme Court can see all entire throughout India. It can take the disputes, but whereas High Courts they have to take only to the state, up to that state area only. For example, you take uh, you take AP High Court, then this has to see only the up to AP jurisdiction. Similarly, Chennai, up to Chennai, Tamil Nadu jurisdiction. So, whatever the jurisdiction available, up to that only that High Court can see that. So, this is what single integrated judiciary we have, whereas USA we have double system of judiciary, where the Supreme Court of United States of America is saying central laws, whereas high courts in America they're saying state laws. This is one point you have to remember. Then you come to articles. Take Article 124. This is regarding establishment of the Supreme Court. So 124.1 you take. Originally, there are. It will say there shall be Supreme Court with one CJI. Okay, one CJI plus 7 judges. This is original constitution. Original constitution. These 7 judges can be changed by parliament by law. Parliament law can change these 7 judges. So, in that regard, there is Supreme Court number of judges Act. So this came in 1956. This 7 has become 10. Okay, 1 plus 7 is there now. So this 7 in 1956 it became 10. 1960 it became 13. 1977 it became 17. 1986 it became 25. 2008 it became 30. 2019 it became 33. So at present we have one Chief Justice plus 33 Supreme Court judges. Total 34 judges in Supreme Court. This is the 124 class 1. If you come to 124 class 2, this is regarding appointment. Appointment of Supreme Court judges. So how here appointment is done? Here appointment, what Constitution says, these are appointed by the President. By President. But President has to consult Supreme Court, High Court judges. He has to consult Supreme Court, High Court judges when he appointing Supreme Court judges. Okay, plus CJI also he will consult CJI. Okay, CJI plus Supreme Court, High Court judge. When he is appointing, when President is appointing CJI, he will consult Supreme Court, High Court judges necessary. It appears necessary for him. It appears necessary for him. So listen carefully. President will appoint President will appoint when his president will appoint Supreme Court judges. When he's appointing Supreme Court judge, when he's appointing Supreme Court judge, he will consult CJI plus Supreme Court High Court judges as he feel necessary. So CJI consultation is mandatory. And when president is appointing CJI, he will consult Supreme Court High Court judges as necessary. This is the constitution given. So here what says president while appointing Supreme Court judge, president shall consult CJI mandatorily plus Supreme Court High Court judges as he feels necessary. Okay, here president shall consult CJI. This is mandatory. This is obligatory as per the constitution. So when in first judge's case, we call this one as SP Gupta case. Okay, first judge's case. Here is important, 1982. Here consultation not equal to concurrence. Means president can ask CJI. Whether CJI, for example, president will ask CJI, should I appoint A? Then CJI says yes or CJI says whatever. That president doesn't care. So whatever CJI says, president can consider or cannot consider. If president say yes also, he can appoint, no also he can appoint. If president wants to appoint. So but it consultation means president can consult CJI, but it is not binding on the president. It is not binding on the president to follow that whatever CJI is saying. That is the this is the in first Supreme Court. Supreme Court said in first SP Gupta case, whatever president consulting, that is not concurrence. Means CJI whatever saying, president no need to obey. It is not binding on the president. That is the first judge's case. Then there is second judge's case. Second judge's case. This is in 1993. Second judge's case. 1 minute. Second judge's case 1993. Here what happened? Consult is equal to concurrence. This is what Supreme Court said. Here what Supreme Court saying? Whatever CJI is saying, CJI, Chief Justice of India is saying, it is binding on the president. And also Supreme Court says president should consult CJI plus two senior most Supreme Court judge. This is what Supreme Court said in the second judge's case 1993. So this is where the collegium system has started. Collegium system began in 1993. So when it comes to third judge's case in 1998, so Supreme Court here said consult is equal to concurrence. Here you have to consult CJI plus four senior most judge. CJI plus four senior most judges you have to consider. Also, if in four senior most judge, next who is going to become next CJ, that person should be there in the 4 senior most. If that person is not available, then you have to consider CJ plus 4 senior most plus next CJ. This should be consultation. So by seeing all these things, there are many criticisms has come. Here, what is exactly happening? Uh, Judges are there. Judges appointing themselves. Okay. Here, what is happening? Actually, president. Actually, whatever this collegium now. Collegium means a group of judges. CJ plus his group. Whatever collegium saying, that president has to obey. That is what Supreme Court said, and that is what collegium system. Now, judges appointing themselves means judiciary appointing themselves. There is no executive. No executive means president. Now, president role has been reduced, almost nil. You can say there is president role nil. In such case, there is a lot of criticism has come. Then government or parliament, you can say, it has amended the constitution, and 99th Constitutional Amendment Act. Okay, 99th Constitutional Amendment Act has come. 99th Constitutional Amendment Act. This has created a NJAC Act also. Okay, and there is National Judicial Appointment Commission. This will appoint judges, Supreme Court or even High Court judges. This is what 99th Constitutional Amendment Act in 2014 has come. But what happened here? National Judicial Appointment Commission. Here, from government side also, members will be there. From ministry, means Union Law Minister, all people will be there. Plus, at the same time, Chief Justice and two senior most judges also will be there. So, NJAC will be appointing. But immediately, what happened? In 2015, fourth judge's case. In 2015, Supreme Court declared 99th Constitutional Amendment Act 2015 plus NJAC Act 2014 actually. Okay, 2014 NJAC Act 2014 unconstitutional. This is unconstitutional. It declared unconstitutional, and what Supreme Court gave reason is the independence of judiciary will be under threat. Okay, it will independence of judiciary will be under threat. So that's why 99th Constitutional Amendment Act 2014 and NJAC Act 2014 has been declared unconstitutional in the fourth judge's case 2015. So now at present again the collegium system is there. So four judges, fourth first judge's case, second judge's case, third judge's case, fourth judge's case. This have to remember. This is the collegium system, how evolved and how appointment of the even Supreme Court also, even High Court judges also, how it is being done. This is 124 class 2. This is 124 class 2. Now you come to 124 class 3. You can say here itself, you remember age 65 years. This is the age for the Supreme Court judge. Retirement age, okay. Retirement age. And he can resign, can resignation given to president. Also, he can be removed. This removal is given 124 class 4. We will see this one. Then 124 2A. This regarding the age of judge. Age of judge is decided by Okay, such manner plus such authority, such manner plus such authority as Parliament by law create. That is 124 2A. Then 124 124 3. 124 3 qualification. What is the qualification? He must be citizen of India plus he should be in 5 years High Court judge in succession. Okay, of one High Court or many High Courts, no issue. Okay, it should be in succession, and also 10 years as a High Court advocate. 10 years as a High Court advocate. First one, he must be citizen of India. First he must be citizen of India, and then in succession he must have at least 5 years as a served as a High Court judge, or in 10 years he should have High Court advocate in the in succession. In succession, this or this. Okay, this or this, or in the opinion of the president. In the opinion of the president, he is a distinguished jurist. Distinguished jurist means expert lawyer, you can say. If he is very talented lawyer, if president feels like that, president can directly appoint him as a Supreme Court judge. Okay, that is 124 3. 124 3. Then you come to 124 4 removal. Very very important. 124 4. Okay, 124 class 4. This is removal. Removal of Supreme Court judge. So this removal can be done by president. This removal can be done by president. This is the first point. And what grounds he can do? Misbehavior or incapacity. Misbehavior or incapacity. Okay, proved misbehavior or incapacity. These are grounds of removal. And how they can be removed by address means here Parliament has to tell to the president, you remove like that, and Parliament has to pass a resolution, you can say resolution by special majority. This special majority is 2/3 of the members present and voting plus total majority. Okay, majority of total membership of the house. This means 50% plus 1. You have to get 50% plus 1. So this is 1 and this is 1. That is what special majority. For example, 100 are there. Let's say how many have come there. Was 2/3 of the members present and voting should. Who were present and voting, in that 2/3 should be voting for that removal bill or removal resolution. Plus there should be 50% one. If you take total membership, 50% one should be there, plus one should be there total. Then only it will come under special majority. You can take some random numbers and you can check for that. It is not required. You simply remember special majority. So when Parliament has to pass a resolution with a special majority, you remove this judge. Then President will remove. What are the grounds? Misbehavior and incapacity, and this has to done in the same session. Okay, this has to done in same session. Means, for example, if you take, there are 3 sessions annually done in by Parliament: budget session, monsoon session, winter session. You remember BMW. Budget session, monsoon session, and then winter session, budget, monsoon and winter session. So for example, in budget session, bill has resolution introduced to remove one judge, then that bill should pass within the budget session. It should not go, for example, Lok Sabha passed in now, like budget session, then Rajya Sabha has not passed, then that bill will lapse, then again freshly you have to take. So within, by completing within one session, means budget session it is introduced, means by budget session, within budget session, both houses should pass it. The bill can be introduced in any house, Lok Sabha or Rajya Sabha, Lok Sabha or Rajya Sabha. So here wherever introduced, first house will investigate the charges, first house investigate charges. First house this is not given in constitution, but it is given by parliament by law. In constitution given this only 3 points. Removal, president can be done when parliament passes resolution with special majority, that is 2/3 members present and voting plus majority of total membership of the house. If you take Lok Sabha, there are 543 members. In 543, 50% plus 1 minimum should be there. Then what are the grounds? Misbehavior or incapacity. Misbehavior or incapacity. This is the grounds, and this should be passed in the, this resolution, removal resolution should be passed in the same session. And there is 124 class 5. This regulates the, okay, parliament by law can regulate removal. Parliament by law can regulate removal. So that's why there is judges, parliament passed Judges Inquiry Act 1968. This year also asked in exam. Judges Inquiry Act 1968. What is this Judges Inquiry Act says? For example, there is Lok Sabha. Lok Sabha is the lower house, no? I put here. There is Rajya Sabha, upper house. So if you want to pass removal resolution, okay, for removal resolution, if you want to pass, let's say if you want to pass in, if you want to introduce in Lok Sabha, minimum 100 MPs should sign that. Minimum 100 MPs should support that. Or if you introduce in Rajya Sabha, minimum 50 MPs should support that bill. Then you can introduce anywhere. Then they have to pass with a special majority actually. Here in this Judges Inquiry Act, this is the given procedure given. What is the procedure? This is first thing is 50 MPs or 100 MPs should support. Then presiding officer, speaker or chairman can accept or reject. Can accept or reject. Okay, if accepted, then speaker or chairman will form 3-member committee. 3-member committee he will form. This 3-member committee, Supreme Court judge is there, plus Chief Justice of High Court, plus distinguished jurist. Okay, distinguished jurist will be there. This 3-member committee is formed by the speaker or the chairman. Speaker means if Lok Sabha it is introduced, then speaker will form the committee. If it is introduced in Rajya Sabha, Rajya Sabha chairman will form the 3-member committee. Then this 3-member committee has to say yes, it is found proved misbehavior or incapacity. Okay, misbehavior or incapacity. Then the house should pass the bill. Then with the special majority, if the house has to pass, then president can remove. So this procedure is important because many bits may be asked from here. If you take this procedure is not given in the constitution itself. 124.5 says Parliament by law can regulate the removal of the Supreme Court judge. In this regard, Parliament has passed the one law, that is Judges Inquiry Act 1968. As per this procedure has been given, that if you want to introduce the removal resolution in Lok Sabha, minimum 100 MPs should support. That is, if you want to introduce in Rajya Sabha, minimum 50 MPs should support. After that, speaker or chairman can accept or reject that removal resolution. If it is accepted, 3-member committee, speaker or chairman should form. Then 3-member committee will find whether any proved misbehavior is there or incapacity is there of that Supreme Court judge. Then accordingly, if it says there is some guilt found or some misconduct for the judge found, then with special majority, then if houses will go with special majority pass that resolution, then president can finally remove the Supreme Court judge. Till now, no Supreme Court judge has been removed. Okay, no Supreme Court judge removed till now. But first time there is Justice Ramasamy. Okay, against him the resolution has been introduced, but in Lok Sabha not passed that bill. So that we could not remove that person or that judge. So Justice Ramasamy, remember, till now no Supreme Court judge was, no single judge has been removed. Even single judge till now there is no removal happened till now. That is one fact. And then who is the first person against this judge removal proceedings started? Justice Ramasamy. Justice Ramasamy. Then 124(6) is the oath. Oath or affirmation. Oath or affirmation of Supreme Court judge. Okay, it is done by President. It is done by President or person appointed by him. Person appointed or nominated by him. That is the 124(6). Then 124(7). This is, there is restriction to practice. Restriction to practice by Supreme Court judge. Means once he retires, after retirement, once he retires, the Supreme Court judge cannot practice anywhere before any authority or any court, he cannot practice. That is 124(7). 124(7). So once you just revise. So there is 124 class 1. This is given number of judges. How many number? There is 1 CJI, 7 judges. And now 1 CJI, 33 judges are there. And there is subsequent amendments to the Act Supreme Court Number of Judges Act. In 1956 it is increased to 10, 1960 13, 1977 17, 1986 25, 2008 30, finally 2019 33. So now there is 1 CJI plus 33 judges. Total 34 Supreme Court judges including CJI. Then 124(2), it is regarding appointment of the Supreme Court judges. Who is appointed? Who appoints Supreme Court judges? President. But President should consult Supreme Court High Court judges. He should consult Supreme Court High Court judges when he is appointing CJI. But when he is appointing Supreme Court judges, he should consult CJI plus Supreme Court High Court judges as President deemed necessary. And when consulting other than CJI, when appointing other than CJI, then for example, he is appointing Supreme Court judge, President appointing Supreme Court judge, then President must consult CJI. But this consult, whether when CJI giving any advice, whether it is binding on the President or not, this came in the first judge's case, this question. That is SP Gupta case 1982. Then Supreme Court said no, President no need to obey. It is not binding on the President. Whatever CJI says, no need to consider. Then consultance is not concurrence. But in second judge's case in 1993, Supreme Court reversed the earlier decision and said consult is equal to concurrence. That is, whatever CJI says, it is not his personal opinion. Whatever CJI says, it is a complete Supreme Court. It is judiciary opinion. So it is binding on the president, and it further says, Supreme Court further says, it should president should consult CJE plus two senior most judges. This is what group CJE plus two senior most, this group came to be known as collegium system. Further, in third judges case in 1998, Supreme Court says you president should consult CJE plus four senior most judges. In four senior most judges, if next CJE is not there, he president has to consult the next CJE also. However, government and other critics seen, constitutional experts, everyone seen, there is judges appointing themselves. So there is some kind of nepotism, etc. There is transparency is not available. No transparency is there. So 99th constitutional amendment has brought, and NJAC, that is National Judicial Appointment Commission, has been created to appoint Supreme Court, High Court judges. However, in 4th Judges Case 2015, Supreme Court declared 99th Constitutional Amendment Act and NJAC Act 2014 as unconstitutional, saying that it will undermine the independence of the judiciary, which is basic structure of the Constitution. Then 124(2) further says 65 years the retirement age, and then if Supreme Court judge want to resign, he can give resignation letter to president. Also he can be removed, and as per 124 class 4 article. Then 124(2) says age of judge, it is decided by in such manner and such authority as parliament by law creates. 124(2) age, you remember, age of the judge decided by parliament. 124(3) qualification, he should be citizen plus 5-year high court judge in succession, or 10-year high court advocate in succession, or in the present of opinion a distinguished jurist. So in out of these three, anyone he can be having, plus he is citizen of India, means he is eligible for the appointment of Supreme Court judge. Then 124(4) removal is given. Who is removed? Supreme Court judge removed by president. What are the grounds? Misbehavior or incapacity. But parliament has to pass the removal resolution with the special majority. That is 2/3 members present and voting, plus total membership of the house majority, that is 50% plus 1. But this should be done in the same session. First house will be investigate the charges. There is 124(5) parliament by law can regulate the removal of the Supreme Court judges. Accordingly, Judges Enquiry Act 1968 has been passed. As per this, if you want to introduce in Lok Sabha that removal resolution, 100 MPs should support. If Rajya Sabha you want to introduce, 50 MPs should support. Then Speaker or Chairman can accept or reject. It is their discretion. If they are accepting, then 3-member committee has to form. Who are there in 3-member committee? Supreme Court judge, CJE High Court, means Chief Justice of the High Court, plus distinguished jurist. If they found guilty, then houses can pass the the bill resolution will be introduced. Removal resolution will be introduced, and with special majority, if both houses are passing, then president finally has to remove that Supreme Court judge. Till now, no judge has been removed. No Supreme Court judge has been removed. Also, the first judge against whom the removal proceedings initiated was Justice Ramasamy. However, Lok Sabha could not pass with special majority, so that has been dropped. Then 124(6) oath or affirmation of Supreme Court judge. It is made by president or person appointed by the president. 124(7) after retirement of the Supreme Court judge, he cannot practice any court or before any authority within the territory of India. That is 124. This 124 is very important article, provisions of the Supreme Court. Then 125 is the salaries of the Supreme Court. 125 salaries. 125 salaries. So salaries are decided by parliament, or until parliament is decided as per the second schedule. And also you cannot reduce cannot reduce salary for their disadvantage. After appointment, except during financial emergency under Article 360. Except during financial emergency under Article 360, you cannot reduce the salary, allowances, etc. of the Supreme Court judge. Okay, who are determined? Salaries are decided by the Parliament until Parliament decided as per the second schedule. That is Article 125. Article 125. Then Article 126. Article 126, acting CJ. So acting CJ is appointed by the President again. When he can be appointed? When it is vacant or when CJ is absent, okay, or otherwise he is unable to perform duties, then President can appoint the acting CJ. He can appoint among one of the Supreme Court judges. There are total 34. So, for example, one CJ is on leave or he is vacant, he is retired and nobody is appointed. Then from one of the judges, President can appoint the acting CJ. Okay, till the appointment of the CJ is done, he will be acting as the CJ. Then 127, ad hoc judges. Ad hoc judges appointed by President. Appointed by CJ, but with the consent of President must be done. Okay, before appointing ad hoc judge, Chief Justice of India should consult consent of President should take, plus he should consult concerned CJ High Court. Okay, actually, who is ad hoc judge? Any High Court judge. Okay, qualified to be judge of Supreme Court. Okay, this one. Any High Court judge qualified to be judge of the Supreme Court. He can be appointed as ad hoc judge by the CJ, but he should take the permission of the CJ High Court. Plus, he should also consult the President. That is ad hoc judge. That is ad hoc. Ad hoc means it is like only temporary provision. But when he can ad hoc judge can be appointed is there when there is a lack of quorum. Let's say to do one Supreme Court whenever there is session, there is a lack of quorum is there, like minimum number of judges are not available. Then CJ, for temporarily, he can ask CJ High Court, you please send some of the High Court judges who are duly qualified to be the judge of Supreme Court. He cannot ask any High Court judge to come and sit in the Supreme Court. He should have proper qualification to become the judge of the Supreme Court. He can ask those High Court judges to come and be present in the work as the ad hoc judge in the Supreme Court. But he also must take a consent of the President. Also, whenever a High Court judge is appointed as the ad hoc judge in the Supreme Court, this High Court judge has to do in priority his duties of the ad hoc judge. Means he is a High Court judge. At the same time, now he has been appointed as the ad hoc judge. So he has to do his priority should be given to work in as an ad hoc judge, not as a High Court judge, though he is a High Court judge. This is 127 ad hoc judge appointed by CJ. Then 128 retired judges appointment. Again appointed by the CJ. Again President consent must be there. President consent must be there. Or president approval should be there. CJI with the approval of the president. CJI with the approval of the president. CJI with the approval of the president. And whatever allowances are there. Okay, just a minute. Whatever allowances decided by the president. Also here, consent of retired judge must. Consent of retired judge must. Let's say one retired judge is he is not willing to come and serve in the Supreme Court, so you cannot force him. If he is willing, yes, you can ask him. Who can ask? CJI can ask. Whether CJI solely can ask? No, he has to take the permission of the president. Who will decide his allowances for this retired judge? President will decide the allowances. Allowances means you have to take out from the consolidated fund. So president has to give permission. Otherwise, no, you cannot take. That is 128. Attendance of the retired judges of the Supreme Court. Retired judges at sittings of the Supreme Court. Attendance of the retired judges. Attendance of the retired judges. Here retired judges can come from federal court or Supreme Court retired judges or High Court judges qualified to become the Supreme Court judges. So these three fellows can become. For example, federal court judge retired, he is sitting at home. Yes, CJ can call him. You please come and serve the Supreme Court. For example, retired Supreme Court judge is there. He is sitting at home. Yes, CJ can call him. Let's say High Court judge, he is retired, but he eligible to become the Supreme Court judge actually. But before that, his age or whatever reasons he retired. Now he can call that High Court judge also to serve the Supreme Court. That is 128. 128. Then 129, Supreme Court to be a court of record. 129. Supreme Court to be a court of record as well as contempt of court. Court of record means whatever it is doing, judgments, everything, judgments, orders, decrees, all this will be perpetual memory. They have to be recorded and they have to be saved, and everyone should follow them. That is there. Court of record. Also, 129 says there is contempt of court provision. Contempt of court means, this is what is contempt of court means. This is not defined in the Constitution actually. Okay, not defined. Okay, not defined in the Constitution. Not defined in the Constitution. This contempt of court is, there is COC Act 1971. Here there is two types of acts. Okay, civil contempt of court, criminal contempt of court. Civil contempt of court, criminal contempt of court. Criminal means any order is given. Supreme Court, let's say Supreme Court has given some order and you are not following that, then it will attract civil contempt. Let's say there is a criminal contempt. Criminal contempt means, for example, let's say you are lowering the authority of the court. Or you, let's say you are interfering in the proceedings. You are interfering in the proceedings of the Supreme Court. Then also it will attract criminal contempt. Or you are attacking the administration of justice. You are disturbing the administration of justice. So when you are doing these things, means you are like blocking the functioning of the Supreme Court. Then it will attract criminal contempt. So these two, civil contempt, criminal contempt, these are available as per COC Act 1971. What is COC? This Contempt of court, it is not defined in the constitution. It is given only contempt of court. What it is not defined in the constitution. This is Article 129. Article 129. Article 129. Now you come to Article 130, seat of Supreme Court. This is decided by CJ with the approval of the President. Okay, other than Delhi. Other than Delhi. Okay, at present seat is at Delhi. If other than Delhi, anywhere you have to put any some other bench, then it is decided by the CJ with the consent of the President, with the approval of the President, with the approval of the President. Then Article 131, original jurisdiction of the Supreme Court. This is says there are three issues. Okay, if any issue is there, center versus state. Okay, then center comma state versus some other states. States versus some states versus other states, or state versus state. These are all federal disputes. Federal disputes means center, state, state, center. These are federal disputes. If any such dispute is there, you have to directly go to the Supreme Court. You cannot go anywhere. For example, there is a fight between AP and Telangana. Then you have to go to Supreme Court directly. Or there is fight between West Bengal and Center Union. Then you have to go to Supreme Court. That is mentioned in the Article 131. Article 131. Article 131. This is the original jurisdiction. Okay, this should be whether question of law or fact of the any legal right. Okay, any legal rights related issues has come, then only you can go. There are some exceptions where you cannot go. For example, any political dispute you cannot go. Any commercial dispute you cannot go. Okay, any private citizen is going and putting the case. No, you cannot go. Any private citizen you cannot. And other than that, any pre-constitutional treaty, any agreement is there, pre-constitutional related, then also you cannot go. And then any agreement excludes jurisdiction, then also you cannot go. Okay, so other than that, interstate river water, any dispute is there, you cannot go. Article 262 says Supreme Court, there is, for example, any fight is there between two states, for example, for some certain river, then those two states cannot go to the article under Article 131, you cannot go to the Supreme Court. These are exceptions. Okay, also Finance Commission matters, anything related, then also you cannot go. Any commercial nature, okay, that you cannot go. So these are the exceptions. Otherwise, the 131 original jurisdiction is there. Then 132, this is appeal. Okay, 132 is appeal. So 132 is appeal. It is appeal. It is constitutional related appeal. Appeal constitutional matters. Okay, these are civil matters. 133. 134 criminal matters. 134A High Court certification. Okay, on own motion, on own or party appeal or party requesting. So here actually there is High Court. From High Court, any judgment, any order is there. For example, you not like that order. Okay, you say High Court has not decided properly. Then you can go to Supreme Court. This is what we say. It is going like appeal. Actually, if any case is there, it should start from lower court. Okay, first you have to go to lower court, from there district court, from there High Court from their Supreme Court. You cannot directly go to Supreme Court. Of course, if there is violation of the fundamental rights as per Article 32, you can go directly to the Supreme Court. That is only for fundamental right violation. For all other cases, you cannot directly go to the Supreme Court. You have to go step by step. So from High Court to Supreme Court, whenever you are appealing, these are three provisions we can say: 132, 133, 134. If anything, if the matter involves the constitutional interpretation matters, then under Article 132, yes, you can go. That for that High Court has to certify. Okay, if High Court certify, there is involvement of the constitutional interpretation. If High Court certifies, then Supreme Court will, under Article 32, you can go directly to appeal. If any civil case is there, then High Court has to certify. That this case involves interpretation of general law of importance, not constitutional importance, general law of importance. Okay, law of general importance. And another one, fit for Supreme Court decide. Fit for Supreme Court. This case is fit for Supreme Court. If High Court certifies these two things, okay, this is law of general importance, and it is fit for Supreme Court to decide. Then that civil appeal, you can go on appeal. Okay. Then you can go to Supreme Court and you can appeal. Otherwise, you cannot appeal. So first one, 132 constitutional matters. If High Court certify, then directly you can go up on appeal. You can go to the Supreme Court and you can file an appeal. 133 civil cases. If High Court certifies that there is law of general importance involves in this case, also it is the fit case for the Supreme Court. Then if High Court certifies like that under Article 134A, then there is a appeal lies to the Supreme Court and you can go to the Supreme Court. This is 133. So there is 133 2. 133 2 says party can appeal saying that there is constitutional matters involvement. In this case, that party also can appeal under civil case. This is party having some right. And there is 133 3. If single judge is there, single judge order. Okay, single judge order, you cannot appeal unless Parliament by law creates. So 133 1 what says, if High Court certifies the case involves the law of general importance and also it is fit for the Supreme Court, then you can go and appeal. 133 2, the other ground, the party can appeal that this case also involves the constitutional interpretation. Then this ground also you can put. Then 133 3 says, if single judge order is there, you cannot directly go to the Supreme Court on appeal unless Parliament by law creates. Constitution has given. As per Constitution, you cannot go. If Parliament by law given, you can go. That is 133 3. So 133, remember, civil cases. 132 constitutional interpretation cases. 133 appeal in civil cases. 134 appeal in criminal cases. 134 appeal in criminal cases. Okay. 134 1 says, here A is there, B is there, C is there. A says on appeal, okay, for example, High Court reversed the lower court order. And sentenced him to death. Okay, it is death sentence. It is given death sentence. Okay, then yes, you can go to appeal to the Supreme Court. Let's say High Court has a withdraw trial before itself from lower court and sentenced him to death sentence. Then also appeal is available in criminal matters. Also in C, High Court certify that it is a fit case. for Supreme Court to decide. Then also appeal lies. Okay, criminal appeal lies in three cases. For example, lower court says he is not guilty, but high court has given he is guilty and we are giving him death sentence. Then Supreme Court can take that case and it can check on appeal. Then, for example, there is pending any case pending. Then High Court is withdrawing from the lower court that case, and High Court saying and decided and convicted him and imposed death penalty. Then also criminal appeal lies to the Supreme Court. In C 134 1C, if High Court certifies it is a fit case for the Supreme Court to decide, then also criminal appeal lies. Then 134.2 says, this is important, 134.2 says Parliament by law can increase the criminal jurisdiction. So accordingly, Parliament has created the law and it imposed two more conditions, two more things. If High Court reverses order and imposes life imprisonment or 10 years imprisonment, then also criminal appeal is there. Also High Court any pending case from lower court has taken and imposed the life imprisonment or 10 years imprisonment, then also appeal is there to the Supreme Court. This Parliament by law has been created. This is 134.2. Then Article 135 says Federal Court. What is the Federal Court power, jurisdiction? That Supreme Court will continue. That is 135. Then 136. Special leave petition. Special leave petition. Petition means request. You are giving some request to someone. Here you are giving request to Supreme Court. Actually, any order, okay, any order you are not liking. So you can request, you can petition, you can give to the Supreme Court. Okay. Supreme Court, it is may agree or may not agree. Okay. That is what special leave petition. It is Supreme Court discretionary. Supreme Court discretion to agree or not. For example, one judgment, one order. For example, lower court, for example, you take any district court has given some judgment. You are not liking that judgment. Then you have to go to step by step. Otherwise, in some cases, you can directly go to the Supreme Court. You can request the Supreme Court. This involves some question of law or fact, whatever. You please decide this case. So here you bypass, you are skipped the High Court. Then this is like special leave petition. It is like Supreme Court can accept or cannot accept. Here Supreme Court mostly will not accept. If Supreme Court will keep accepting every question or every case, it will pendency will still keep on increasing. So here Supreme Court itself says you have to use this 136 Article 136 special leave power. This is extraordinary power and it should be used cautiously. You should allow the most important case like that. This is special leave petition. Special leave petition. This is discretion. Okay, any order, any pending, any court or tribunal. Okay, any order given by the court or tribunal, any court or tribunal, that can be decided and you can appeal to the Supreme Court, and if Supreme Court may or may not agree, it is discretion. That is what this is special power available to the Supreme Court. It can take up the case on request. Okay, any court or tribunal except, this is important, except court martial or military court. Court martial means military court. Military court orders, yes, you cannot take to the Supreme Court. Then 137 review of the Supreme Court. Sometimes what happens, Supreme Court will review its own judgments. For example, if you take Supreme Law case, it has given women were allowed. Again, now it is reviewing its judgment. So like that, Supreme Court can review its own earlier judgments. Of course, it can reverse the earlier decisions also. For example, if you take the first judge's case, president no need to obey the CJI orders, it said. However, subsequently in second judge's case, it reviewed its judgment, it said it reversed the earlier decision. That is Article 137, review. 137, review. 138, enlargement of the jurisdiction. Jurisdiction can be enlarged. How? By Parliament. Parliament, you remember, Parliament cannot curtail but increase jurisdiction of the Supreme Court. Parliament cannot reduce the jurisdiction of the Supreme Court. If want, you can give more powers, more jurisdiction to the Supreme Court. That is there. And then 139, writs. So this also Parliament can give. Parliament by law can give any other writs. For example, if for any other purpose. For other purpose other than those in part 3 or part 3 of Article 32. If you take Article 32, there is for fundamental rights violation. If fundamental right is violated, you can directly go to the Supreme Court. That is what Article 32 says. If other than fundamental rights, for example, any other right is violated, then also you can go to the Supreme Court. Like that, Parliament can give extra powers. Okay. As of now, as per the Constitution, only if there is violation of the fundamental right, you can directly approach to the Supreme Court as per Article 32. But if for any other purpose you have to give writs, then Parliament by law can give to the Supreme Court. Let's say you are violating this X right or Y right, then you can directly go to the Supreme Court. Like that, Parliament can create a law. That is Article 139. 140, ancillary powers. Ancillary means any in exercise or jurisdiction of the Supreme Court, if any other powers are available adjacent to that or related to this, then Supreme Court can have those powers. That is 140. 140 ancillary powers. 140 ancillary powers. Then 141. Okay, law binding on all courts. Okay, whatever Supreme Court says, whatever Supreme Court giving, all those judgments, everything, it is binding on all courts. That is high courts, subordinate courts. That is lower courts. It is binding, whatever that. Then 142, to do complete justice. 142, you remember two words, complete justice. To do complete justice, Supreme Court can issue any order, any decree. Okay, any judgment. Any order, any decree, any judgment to do complete justice. It can, whatever order issuing, it is a law, you can say. That is 142. Huge powers are given in 142. That is 142 class 1 actually. 142 class 1. Under 142 class 2, it can call any person, okay, and it can ask for any document, any evidence. Supreme Court can ask. So 142 mainly remember this one, complete justice. To do complete justice, Supreme Court can issue any order. To do complete justice. Then 143. 143, this is what generally called advisory jurisdiction. Advisory jurisdiction. Here what happens, 143 class 1, class 2 is there. Here, any question of law or fact is there. President will ask to the Supreme Court. Then Supreme Court may or may not give. Okay, it may or may not give. May not give Supreme Court its opinion. But let's say any pre-constitutional disputes or question is there, pre-constitutional question or any complaint. Then if President asks to the Supreme Court must give. Okay, in Constitution it is written shall. It has to must give. Supreme Court must give the opinion, the Supreme Court opinion. So till now, under advisory jurisdiction, President has referred 15 times the opinion of this CJ. So 15 times the question is referred to the Supreme Court. Then 15 times. That number you can remember. So 143 1 says if any question of law or fact, Supreme Court may or may not give. Pre-constitutory, Supreme Court must give its opinion. Okay, in both cases, it is not binding on the president. Both cases, not binding. Not binding means president may or may not follow that advice. It is president wish. Then 144. All civil and judicial authorities act in aid of the Supreme Court. Act in aid of Supreme Court. That is 144. 145 rules of the Supreme Court. Okay, there are some rules, okay, made by Supreme Court with president approval, subject to law of parliament. Subject to law of parliament. Okay, there are some rules. Okay, 145. These rules you can say regarding, okay, appeal procedures, okay, practice. Okay, for example, under part 3, you are directly going to the Supreme Court. How that proceeding should be there. And there is 139A proceeding. I will tell this one. And then 134 1C. Okay, and then regarding stay. Okay, regarding bail rules. Regarding bail rules, etc. All these rules are framed by the this is 145 1 law. 145 1. These rules are given in that. Then 145 2. Okay, fixing number of judges to decide the questions. Okay, and single judge power. Okay, or division bench power. These are as per 145 2. Then 145 3 constitutional bench. Constitutional bench. It should not be less than 5. Any constitutional question, any case involves the constitutional interpretation. Minimum number of judges should be 5. Minimum number of judges should be 5. That is 145 class 3. 145 class 3. 145 class 3. For example, let's say one case, for example, related to governor. Okay, there is governor issue is there. That is as per the constitution. So now let's say Article 200 assent to bills. Now that is referred to the constitutional bench. Means minimum 5 judges should be there in that bench. Then these 5 judges only can decide that case. That is what a constitutional bench. Constitutional bench. Article 145. Article 145 class 3. Article 145 class 3 constitutional bench. Constitutional bench, not less than 5 members will be the available. And then Article 145 class 4. Article 145 class 4. Article 145 you have to give judgments. Okay, you have to give orders are delivered in the open court. Open court. Okay, including under Article 143. When president is asking for opinion, it also should be delivered in the open court, and then it is given to the opinion should be conveyed to the president. Then Article 145 5. This majority should be there when giving judgment. Majority, for example, 3:2. For example, 5 judges are there. 3:2 is the majority. Then dissenting can also be given. These two are dissenting. Dissenting means whoever not liking, whoever have to give opposite judgment. Yes, they can give. If you don't like that case. I mean, whatever your opinion, dissenting opinion also is allowed. Dissenting opinion also allowed. This is 145. Then 146. 146. Officers and servants of Supreme Court and expenses of the Supreme Court. So officers and servants and expenses of the Supreme Court. Expenses of the Supreme Court are charged upon the they are covered under the charged expenditure. This important word is important. Means the charged expenditure means the parliament no need to vote. Actually, if you want to withdraw any amount from the consolidated fund of India, Parliament has to pass the appropriation bill. Appropriation means you can withdraw with the that permission you have to get. That is appropriation bill. Then only you can withdraw any even 1 rupee from consolidated. But if it is charged expenditure, it comes under the charged expenditure. Then no vote is available. Then no vote is available means your expenses or your salaries are there is no one can block, even the parliament cannot block it. That is guaranteed by the constitution. That is charged expenditure. Then officers and servants, they are appointed by, okay, 146 appointed done by the CJI or any judge nominated by him or any officer nominated by him. CJR, any judge nominated by him or any officer nominated by him. However, who is not already attached to the court or to the office of this Supreme Court, then President may by rule require, okay, you have to consult to the Supreme Court. CJ has to consult to the Supreme Court. Sorry, UPSC. Then only you have to appoint that person. That is what 146.1. 146.2 says conditions of service. Service of officers and servants. Conditions of service. Conditions of service means here all rules, whatever conditions of service, all are made by CJI. However, salary, etc., you have to take the president approval. President approval. Then 146.3 charged expenditure, all the expenses. So 146.1 it is appointment. 146.1 appointment of the officers and the servants. Appointments of the officers and servants. It is done by the CJI or judge nominated by or officer nominated by him. If anyone not already attached to the office, CJI cannot appoint him directly. He has to consult the Supreme Court. UPSC, Union Public Service Commission. Then only you have to appoint that person who is not already attached. Then under 146.2 conditions of service of officers and servants. This is again rules made by the CJI. However, salary, etc., if you want to decide, then president approval has to taken with respect to those officers and servants. In 146.3 charged expenditure, those expenses covered under charged expenditure. That is, Parliament no need to vote. It is already guaranteed by the Supreme Court. Constitution. It is guaranteed under the Constitution. There is no need to vote to withdraw from the Consolidated Fund of India. Then final Article 147 is there. It is related to interpretation. This is not required. You simply remember it is some related to some interpretation. Okay. Some interpretation. So we have covered 124 to 147. 147 articles, 124 to 147. So you can just go through again the video if you feel it is faster. You can just go through and you also refer to the constitution if you have any doubt. that constitution language is somewhat tough. I simplified here, and you can watch this if you don't understand again. And you keep writing, have some your own notes, so that it will be very easy to you to revise it. Thank you.